Hello, my name is Jason Lacy, and I'm an attorney with the law firm of Denton and Coiler here in Paducah. On today's segment of the People's Law School, we will be discussing long-term care issues with specific emphasis on Medicaid issues. Today I'm also joined with another attorney from Denton and Coiler, and that's Miss Melissa Yates. As I said, today's issues will focus on long-term care and Medicaid. And these are some of the most often confused areas of law. Today, our goal is to provide you with a general understanding of long-term care and Medicaid with specific emphasis on things such as qualifying for Medicaid, income and asset limitations on those type of people who can qualify for Medicaid, specific planning methods for transferring or gifting your property, as well as some discussion about estate recovery and what that might mean to your estate plan. So first off, Melissa, I suppose it's a good idea to just first of all give the audience an idea of what long-term care is and just kind of clear up what that buzzword really means.
Long-term care is typically considered to be something along the nature of custodial care. It's assistance for people who are unable to meet their own activities of daily living. Things such as being able to feed themselves, dress themselves. They may have issues of continence or just mobility issues. So really we're talking about helping people with those types of activities.
Right. Now why is long-term care such a big issue, especially for the elderly population?
Well, there is a statistic out there that probably more than 50% of people who reach age 65 at some point in their lives are going to need some sort of long-term care. And typically it becomes a concern because it's usually a very large expense for people.
Right. And speaking of long-term care, what are the various options available to people to help meet those long-term care needs?
Well, there are several options available. One is to rely on family or friends. Sometimes that's a good option, sometimes it's not. Sometimes it's just not possible for family and friends to provide the type of care that a person needs. Another option would be self-insurance, which would mean essentially that you would pay for yourself as you go. In other words, as you need the care, you would pay for it out of your own assets and income. Another option would be long-term care insurance, which is essentially a policy of insurance that you purchase that covers some or all, depending on the type of policy that you purchase, of the expenses associated with long-term care. One of the benefits of long-term care insurance is that you can also purchase riders for assisted living or even for care at home, so that you don't actually have to go to a nursing facility, because most people would prefer to be at home if in the event they require this type of care. The fourth option for most people would be Medicaid, because Medicaid is the only government program that pays for custodial care.
Right. And obviously this is an area that has a lot of legal hurdles to get through in order to get the kind of care you need and to plan your estate properly. So what would you tell somebody when they asked you why they need to go talk to an attorney about long-term care issues?
Well, one of the reasons, because it's fairly complicated. If you're dealing with the issue of family or friends who are taking care of you, there are still legal issues that come up with regard to being able to manage assets or make health care decisions. Mm-hmm. Long-term care insurance, sometimes it's helpful to have a third party who is not selling the policy to look over it or to advise you as to what options are available or may be advisable in that policy. With regard to the issue of Medicaid, it can be tricky to qualify. The rules and regulations are complicated, and sometimes it takes a legal mind to be able to work through those issues.
Sure. And as far as the different types of long-term care, I realize there's skilled care, there's skilled nursing care, and there's also custodial care. Could you give the audience an idea of the difference between those two?
Sure. Skilled care is more of a situation where, say, someone has an acute type injury or problem where they are going to be receiving therapeutic services to help get them better, essentially. And custodial care, typically there's not a prospect that someone is going to get better. It could happen, but typically we're talking about someone whose condition is going to remain the same or may even get worse, and they're going to need assistance with those activities of daily living.
And speaking of those activities of daily living, I know those are toileting, bathing, dressing, eating, transferring incontinence. Are those, what are the requirements in order to qualify for Medicaid as far as those activities of daily living go?
Essentially, you have to meet 2 or more of those activities of daily living in order to qualify.
Okay.
You need assistance with 2 or more.
Okay. And we often hear a lot about Medicaid, and there are lots of, I think, confusing myths about Medicaid and what types of coverage it gives you. Could you give an idea to the audience of what exactly Medicaid is?
Well, Medicaid is a jointly funded by the state and federal government program that essentially provides medical assistance for people who are either age 65, blind, or disabled. And you have to meet certain asset and income limitations in order to qualify for Medicaid. It's really intended for those individuals who are unable to provide for their own medical needs.
Sure. And once again, why would you maybe need an attorney to help you get through all these hoops with qualifying for Medicaid?
Because sometimes there are issues with regard to income. You can only have a certain level of income. For 2007, if you have more than $1,869, you're required to have a special kind of trust set up in order to qualify for Medicaid. Obviously, they would probably need an attorney to get the trust set up and get it funded properly. Another reason is because there may be issues with regard to qualifying them. Sometimes you have to go through a process where you make a Medicaid application and it may be denied, and sometimes you'll have to go through an appeals procedure, and most people feel more comfortable having an attorney assist with those.
Right. And just for a minute, I'd kind of like to go over some of the common myths about Medicaid that some of the people hear. I know I've had various people come into the office and they say they've heard this, that, or the other from different people about what things can cause problems with Medicaid. For instance, is it true or false that married couples do not have to give everything to the nursing home to be eligible for Medicaid?
That's true. Married couples are not required to spend all of their assets in order to qualify one of the spouses or both of the spouses for Medicaid.
Right.
And sometimes whenever I have married couples who come into the office, they often feel better once they've sat down and discussed it with me because they understand that, more thoroughly, and they understand because Medicaid speaks in languages of a nursing home spouse and a community spouse. It often makes the community spouse feel much better knowing that they're not going to have to get rid of all their assets so that they can qualify the nursing home spouse for Medicaid.
Right. And obviously another big issue with Medicaid is a lot of people come in and they ask, can I give away my property? What should I do as far as gifting my property, whether it's to my family or friends? Are there any restrictions on gifting?
An individual is free to give away as much or as little of their property as they want to. Now, that's not saying that there may not be ramifications with regard to either the IRS, there could be tax implications, or there could even be a penalty period imposed by Medicaid. But Medicaid cannot prohibit you from giving away your property or making a gift of property.
Sure. And I think probably the most common thing I hear from people is, if I qualify for Medicaid or if I have to go to the nursing home, is the nursing home going to come and take my house?
I've heard that one quite a bit myself, and the answer is no. What you're really looking at is a nursing home is a private corporation usually. They are going to send you a bill. They're not going to request that you sign over your house to them or that you give them your house. They want to be paid for the services that they've provided. So they are going to bill you, and sometimes that does require that a person's home be sold in order to pay that bill.
Right.
But no, the nursing home nor the state doesn't take the house, so to speak.
And usually they don't have the resources to do that.
Right.
Is the big reason. And I assume the same is true for Medicaid as well.
Yes.
Obviously they can't handle it either. Okay. Well, speaking of, we've touched a little bit on the asset and income limitations for applying for Medicaid. Could you kind of give a clear picture to the viewers of what exactly those income limitations are that would allow you to qualify for Medicaid? And if you do happen to go above those limitations, what you might be able to do to solve that problem?
Well, the requirements differ depending on whether you are married or single. For a single individual who is trying to qualify for Medicaid, they're not allowed to have more than $2,000 in what we refer to as countable assets. And those are things such as bank accounts, savings accounts, investment accounts, generally we think of things that are cash or are easily converted to cash as countable assets.
Right.
That, for most people, it gets a little confusing because it also includes whole life insurance policies. So even if someone has an insurance policy that's only worth a couple of $1,000s, it could keep them from qualifying. Another big issue that's been coming up a lot in my practice is dealing with annuities, because a lot of people purchase annuities, and a lot of times they are causing them to be disqualified for Medicaid purposes because they'll have a cash value.
Mm-hmm. Exactly. And especially now speaking for married people, what kind of impact is it going to have on the community spouse, the one that stays at home? What kind of income limitations will they have as far as, what monies they can receive while their other married partner is obviously in the nursing home and receiving Medicaid benefits?
Well, there is a limitation on the income of the nursing home spouse, but the community spouse is really not so limited in the amount of income that they receive. What really is beneficial to most community spouses is if the nursing home spouse has a higher income than the community spouse, you can essentially transfer part of the nursing home spouse's income to the community spouse in order to bring them up to a minimum level of around $1,600.
Okay.
So it keeps the community spouse from being impoverished.
Right.
And not having enough money to live on.
So for those people in the audience who might be thinking this is an option that they would have to explore in the future, if they fall in that category, which a lot of people will, where their countable assets are above the limit, what kind of techniques and methods should they think about before they maybe think about going and applying for Medicaid benefits?
Well, one of the things you have to consider with a community spouse, if you have a nursing home spouse and a community spouse, the asset limitations are quite different. The nursing home spouse is still going to be limited to only $2,000 in countable assets. But between those two spouses, they may have assets that are not countable. As an example, IRAs are not countable. If the community spouse is living in the home is not countable. They're able to exempt a car. They're able to exempt two cars, one of unlimited value and the second if it has an equity value of less than $4,500. So there are some considerations there with a community spouse that you don't have with a single person. There's also the consideration of the asset limit that a community spouse is set, because Medicaid, whenever they're determining how much the community spouse is allowed to keep, they look at both spouses. So really what they do is they take the total value of the assets that are listed in both spouses' name, essentially they divide them in half. And whatever that number is, if it falls between $101,640 and $20,000, that's the maximum that the community spouse is going to be allowed to keep. As an example, if a couple between them had $170,000, then essentially you would divide that in half, so that the community spouse would then be allowed to keep $85,000, and then the nursing home spouse would be allowed to have $2,000, so essentially they would have $87,000. The remainder would be subject to a spend down, which is essentially where you spend the money in order so that the community spouse then gets to the appropriate level. And when they reach that level, then the nursing home spouse can qualify for Medicaid.
Right.
And there are some techniques that we can use in order to assist with that. One of the most commonly used, one of the things I refer people to the most, is probably, if they have a home, to go ahead and do any necessary repairs, because they're allowed to spend that money however they see fit. They can, part of it obviously will have to go to pay for the nursing home spouse's care until they can qualify for Medicaid, but they're able to make repairs to their home. They could purchase a new car, anything that couple might need individually or between them to make themselves more comfortable, or just anything they might need, they're able to spend on.
Now, what about the timing of the spending on these things, such as fixing up the home and purchasing any, the car? You mentioned the car of unlimited value and an additional car up to $4,500 of value in equity. Are there any certain time limitations or that people should be concerned about as far as when they should do these things and when they should not?
Not as far as when they're purchasing, not as far as conducting a spend down. The important thing that they need to realize is that it only counts as a spend down if you have actually made a Medicaid application, or if you have done a resource assessment through the Medicaid office.
Okay.
So, if they have not done either one of those things, then they could be actually lessening the amount that the community spouse will be allowed to keep.
Right.
Because until you have it on record with Medicaid, it's not determined.
Right.
So.
Right, exactly. And could you give us an idea, obviously there are some assets that are countable resources that go into this $2,000 determination of assets that a person has. Could you kind of give a rundown of some of the things that might be exempt, that
Sure.
people wouldn't have to count?
Yeah, that goes back to the automobile. That goes back to the home, IRA accounts. If there is a term life insurance policy, certain amounts you're allowed to set aside for burial reserves, or perhaps an irrevocable burial trust. It depends on how the funeral arrangements are made. Things like that you are able to set aside. They're basically things that don't have a lot of cash value. One of the things that is really a benefit for Medicaid applicants is that if they have a life estate in property, which is sometimes also referred to as a lifetime dowry, I have clients refer to it as that frequently, that is not countable as an asset.
Okay. And I assume then it's allowable then for these people to spend any money on these exempt assets as a part of their spend down process.
Absolutely, absolutely. The only thing that I recommend to my clients is if they are in this spend down period, they really need to keep very accurate records of the amounts that they're spending so that they can prove that they haven't been making gifts of the property. And like I said earlier, they're free to make gifts, but there are some ramifications whenever it comes to Medicaid.
Now, as far as determining eligibility for Medicaid, does the Department for Community-Based Services look at the assets of both spouses, or is it just the one that's applying for Medicaid?
They look at the assets of both spouses, and most often in my practice this comes up where we have a couple who maybe is in a second marriage. Perhaps they were married for many years beforehand and their previous spouse is deceased, and now they've remarried, so they both have children. They come into this marriage and they both have children from previous marriages, and sometimes they'll even have a prenuptial agreement, but for Medicaid purposes it really doesn't matter. They don't look at how the assets are titled or how long you've had them or who brought them into the marriage. They look at the marital assets as a whole.
Okay. And I touched on earlier, one of the big things people want to do, or they think they should do, is to transfer or gift a lot of their assets in order to help qualify for Medicaid. And I suppose it would be a good idea to kind of mention to the audience what some of the pitfalls are of just going out and doing that, and what are some of the different techniques you might think about doing whenever you're thinking about transferring or gifting property.
Well, gifting is absolutely a method that we use sometimes in order to get someone in position to qualify for Medicaid. The problem is that gifting has to be done well in advance. So you are looking at, because like I said earlier, Medicaid can't keep you from giving anything away, but they can penalize you for it in the event you need to qualify for their services. And essentially what they do is they look at what you give away, and to Medicaid everything is a gift unless you prove it isn't, and essentially it's a transfer for less than fair market value. So if I were to give someone cash, that would be considered a transfer for less than fair market value. If I sold them a piece of real estate for less than what it was actually worth, then that is considered a transfer of resources, and they can impose their period of ineligibility for that. I often get asked whether or not Medicaid can make you give back something, in order so that someone could qualify. In other words, if, say, a mother had given her son a piece of property or some cash, can Medicaid make that son give it back? And the answer is no, they can't, because it's a completed gift. So they can't force it to be transferred back to the mother. But what they can do is they penalize the mother and say, basically, you gave something away when you could have paid for your own care in this long-term care facility, and so now you can't, we're going to penalize you for it. Right. In other words, we're going to disqualify you from our program.
Right. And I know one of the big buzzwords that people come in and ask me about is this look-back period.
Yes.
And I know that has undergone some changes in the past few years. Could you kind of give the audience an idea of what this look-back period means? Sure. And how it could affect their ability to qualify for Medicaid?
the way it works is whenever you give something away, Medicaid looks at it. Whenever you make your Medicaid application, let me back up a little. Whenever you make your Medicaid application, Medicaid asks, within the past 5 years, have you given anything away? Or have you transferred anything into an irrevocable trust? And if the answer is yes, then they look at when the transfer was made and they calculate a period of ineligibility. And for transfers that were made after February 8th, 2006, the penalty is calculated differently from what it was calculated prior to that. After February 8, 2006, and I keep referring to that date because that's the date that the Deficit Reduction Act was signed into law, essentially what they do is take the value of what you gave away and they divide it by what's called the transfer resource factor in Kentucky, and it's a number that approximates the cost of nursing home care per month in the state of Kentucky. And that tells Medicaid a number of months. Essentially take the amount given away, divide by the transfer resource factor, equals a number of months that that person is ineligible for Medicaid. And what they do is that penalty period starts to run from the date you would otherwise qualify for Medicaid, which can be problematic because if someone gives away, let's say something, not terribly valuable, but $10,000, which would, keep them under the gift tax issue with the IRS, it would still trigger a period of ineligibility as far as Medicaid purposes. So essentially we'd take the $10,000, divide it by the transfer resource factor, which is about $4,500 for this year. So let's say that would come up with a period of about 2.25 months that they would be ineligible for Medicaid. Well, the problem is that penalty period only starts to run on the date they first really need Medicaid. So if someone's been in a nursing home for a few months and, the month that they actually need to qualify for Medicaid and don't have funds available to pay, then that's when that penalty period starts to run. So then you've got that period of 2 and let's say a quarter months that they really don't have the resources available to pay, and Medicaid won't pay either until that 2 1/4 months is up.
So another question I often get on this look back period issue is, a lot of people I think are under the mistaken impression that that means they can only be penalized for a period up to 5 years. And I believe that is incorrect. Could you kind of talk a little bit about that?
Yes, absolutely. The penalty period that Medicaid can impose is unlimited. It could theoretically, if you gave away enough, it could be 100 years. It could be, long enough that it would certainly, outlive you. And the problem, the issue really becomes, when do you make your Medicaid application? And if it's made at the incorrect time, then yes, you can have a penalty period that extends well beyond 5 years. If your Medicaid application is made at the proper time, then 5 years may be the maximum. And really that becomes an issue of, when do you make your Medicaid application? When was the gift made? So, and it's particularly tricky if you have a client who made gifts prior to the enactment of the Deficit Reduction Act and after, because the penalty period for those gifts would be calculated differently. It could really cause them quite a bit of trouble. I always advise people, if they are going to make gifts before they make a Medicaid application, that they do consult with an attorney.
Right.
Because sometimes you need to figure things out before you actually make the Medicaid application, because the penalty period could be longer than 5 years.
And I suppose it's also important to discuss for a second there are some transfers that can be made that will not trigger a period of ineligibility. And could you kind of touch on those for a moment?
Between spouses, you're allowed to transfer. A husband can transfer to a wife can transfer to a husband, and there's no penalty period. And we see that a lot whenever we have one spouse going into a nursing home and one staying at home and remaining a community spouse. We'll often transfer from the spouse who's in the nursing home to the other spouse. And one of the reasons for that is, first of all, it facilitates going through the spin down and qualifying process. But secondly, it also assists in that you don't want an individual who's in a nursing home receiving Medicaid benefits to inherit a lot of property from the community spouse. And if you put it in just the community spouse's name, you can make sure that it is, if something were to happen to the community spouse and they passed away, then it would, pass to their children or to whoever they designated in their will.
Right. And I think obviously the big part that a lot of people worry about is when, mom or dad pass away, the person who's been getting these Medicaid benefits, what is the state going to do to try to recover all those costs that they paid on behalf of mom or dad? And that kind of gets us into the area of estate recovery. And could you kind of touch a little bit on how estate recovery works and what, basically what you have to look out for in that process?
Well, under federal law, all of the states that participate in the Medicaid program are required at the death of a Medicaid recipient to try to recover the value of the payments that they made from their estate. Usually, it's not a problem because normally a Medicaid recipient, if they're only allowed to have $2,000, is not going to have much in their estate. A couple of years ago, Medicaid actually made a change in their law so that they claim they can now attach to assets that traditionally pass outside of probate. Their position is that they can attach to joint tenancy properties, perhaps life insurance policies, although that may conflict with a provision of the insurance code, and that they can attach to life estate properties. And traditionally, these are not things that pass through your estate and your creditors don't have a claim against.
Right. And obviously, when we talk about this Medicaid planning, this is just a small portion of what is an overall estate planning issue that people need to think about. Can you touch on some of the other things that when people think about doing some Medicaid planning, some of the other areas of just general basic estate planning that people should consider?
Well, one of the things, I generally have a checklist of things that I think people ought to consider whenever they come in to talk to me about Medicaid planning. One is, do they have their wills in place? Is there a need to have a will in place, or will the laws of intestacy be okay for them? And typically we lean on the side of having a will just because I think it makes it more clear what their intentions are. But that's often something that will come up, and especially in the realm of nursing home spouse, community spouse, because like I said earlier, we don't want the nursing home spouse to have a large inheritance from the community spouse, and the reason is not to disinherit them, it's because you don't want to interrupt their Medicaid benefits. Because once you get those, those are a tremendous benefit, and you don't want to disrupt those because you don't want to disrupt their medical care mostly. Additionally, the purpose behind most Medicaid planning is that most people are trying to preserve some estate to pass on to their children or to family members. And if we, allow the nursing home spouse to have a large inheritance, then essentially all of that money, until they get down to $2,000 again, will have to be spent on their care and on nursing home costs.
Right. And I know a lot of people out there might have some issues with disabled children as well. Are there some things that can be done for disabled children to help preserve some assets from their estates as well?
Absolutely. Transferring, there are several options available that allow someone to be able to transfer property to disabled children, and it does not trigger that period of ineligibility. One example is you can transfer your homestead property to a disabled child, and they might be able to, prevent that period of ineligibility from being triggered.
Okay. Well, Melissa, I think that's all the time we have for today. So I appreciate you helping us out today. And we both hope that you members of the audience have learned a lot. Obviously, this is an area of law that can be very complicated, can be very confusing. So we hope we've given you at least a basic outline of some of the things you should consider in this area of law. And thank you for joining us on this segment of the People's Law School.